Jai Hind to all of you. I am Updesh Kumar Jaiswal, working as an assistant professor in Department of CSC, Ajay Kumar Garg Engineering College, Ghaziabad. Today, I am going to discuss the topic Introduction of Intellectual Property and Information Technology Act 2005. These two topics are coming under the subject Constitution of India, Law and Engineering, KNC 501. The today outline of my lecture is Introduction of Information Technology Act 2000, Objectives of the IT Act 2000, Features of the Information Technology Act 2000, Applicability of the IT Act 2000, Non-applicability of IT Act 2000, Meaning of intellectual property, Types of intellectual property, and then references. Information Technology Act 2000. In 1996, the United Nations Commission on International Trade Law adopted the Model Law on Electronic Commerce, that is e-commerce, to bring uniformity in the law in different countries. Further, the General Assembly of the United Nations recommended that all countries must consider this model law before making changes to their own laws. India became 12th country to enable cyber law after it passed the Information Technology Act in year 2000. It is also called as IT Act 2000. While the first draft was created by the Ministry of Commerce, Government of India as the E-Commerce Act 1998, then it was redefined as the Information Technology Bill 1999 and finally passed in May 2000, so it is called as the Information Technology Act 2000. The next question is, what are the objectives of the IT Act 2000? Why this act was established? The Information Technology Act 2000 provides legal identity to the transaction done via electronic exchange of data and other electronic means of communication or electronic commerce transaction. IT Act 2000 involves the use of alternatives to a paper-based method of communication and information storage to facilitate the electronic filing of documents with the government agency and also their relevant departments. IT Act 2000 is the primary law in India dealing with cyber crime and electronic commerce, that is the e-commerce. So it is the primary law in India. IT Act 2000 grants legal recognition, identification to all transactions done via electronic exchange of data in place of the earlier paper-based method of communication. IT Act 2000 gives legal identity to digital signatures for the authentication of any information or matters requiring legal authentication, legal identification. IT Act 2000 also facilitates the legal electronic storage of data. IT Act 2000 gives legal sections as also facilitate the electronic transfer of funds between the banks and financial institutions like NABARD, etc. IT Act 2000 grants legal identity to bankers for keeping the books of account in electronic form. That is called as the e-passbook, like that. Features of the Information Technology Act 2000. What are the features IT Act 2000 have? The first important feature is all electronic contacts made through secure electronic channels are legally valid. Second point is security measures for electronic record and also digital signature are in place. Third important feature is a procedure for the appointment of officers for judging and holding the inquiries under the Act is finalized. Provision for establishing a cyber regulatory appellate tribunal. In Hindi, it is called as the Cyber Appellate Nadhikaran under this Act. Further, this tribunal will handle all appeals and made against the order of the controller. This Act provides legal identification for digital signature. So, we can say it also provides legal recognition for digital signatures. An appeal against the order of the Cyber Appellate Tribunal is possible only in the High Court. Digital signature will use an asymmetric crypto system. Asymmetric crypto system is the sender and receiver both have different keys, and also a hash function to provide the more security. Provision for the appointment of the controller of certifying authority, in short is called as the CCA, to license and regulate the working of certifying authorities. The controller to act as a repository of all digital signatures. The 10th feature is the Act applies to offences or contraventions committed outside India also. Senior police officer and other police officer can enter any public place for search and arrest without the warrant. The 12th feature is ITAC 2000 has provisions for the constitution of a cyber regulation advisory committee to advise the central government and controller. Applicability of the IT Act 2000, where IT Act 2000 is applicable. According to the section 1(2) of the IT Act 2000, it extends to the entire country, which also includes Jammu and Kashmir. In order to include Jammu and Kashmir, the Act uses Article 253 of the Constitution. Further, it does not take citizenship into account and provides extraterritorial jurisdiction. Section 1(2) along with Section 75 specify that the Act is applicable to any offence or contravention committed outside India as well. If the conduct person constituting the offence involves a computer or a computerized system or network located in India, then irrespective of his or her nationality, the person is punishable under the Act. But the drawback is that international cooperation is the only limitation of this provision. If cooperation will be good among the countries, then punishment will be given to the culprit people which is belonging to the another country. Non-applicability of the IT Act 2000. According to Section 1(4) of the Information Technology Act 2000, the Act is not applicable to the following documents: execution of negotiable instrument under Negotiable Instrument Act 1981, except checks, bank checks; execution of a power of attorney under the Power of Attorney Act 1882; creation of trust under the Indian Trust Act 1882. So here IT Act 2000 is not applicable. Execution of a will under the Indian Succession Act 1925, including any other testamentary deposition by whatever name called. entering into a contract for the sale of conveyance of immovable property or any interest in such property. Any such class of documents or transaction as may be notified by the central government of the Gazette. Now, intellectual property rights. The next important thing related to IT Act 2000 is the intellectual property right, that is called as the IP rights. What is intellectual property? Intellectual property, in short, it is called as the IP, refers to creation of the mind, such as invention, literacy and artistic works, designs and symbols, names and images used in commerce. Types of intellectual property: copyright, patents, trademarks, industrial design, geographical indication, trade secret. Here I am giving the brief introduction of all about this one by one. The first is copyright. It is a legal term used to describe the rights that creators have over their literary and artistic work. It is represented by the symbol C, like this. Works covered by copyright ranges from books, music, painting, sculpture and films to computer programs, databases, advertisements, maps and technical drawing. Next, patent. A patent is an exclusive right granted for an invention. Suppose I am doing an invention, then I should take the patent so that my invention should be disclosed from the other, and only the benefits is given to me, provided to me. Generally speaking, a patent provides the patent owner with the right to decide how or whether the invention can be used by other. In exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document. Next is trademarks. A trademark is a sign capable of distinguish the goods or services of one enterprise from those of other enterprise. Trademarks date back to ancient times when artisans used to put their signature or mark on their products. Different industries use their different trademarks. Adidas shoes have some different trademark, Puma shoes has some different trademark. So trademark is also an intellectual property. Industrial design. An industrial design constitutes the ornamental or aesthetic aspect in an article. A design may consist of three-dimensional features such as the shape or surface of an article, or two-dimensional features such as patterns, lines or colors. Geographical indication. Geographical indication appliances gives the origin and sign used on goods that have a specific geographical origin, emphasis, quality, a reputation or characteristics that are essentially attributable to that place of origin. Most commonly, a geographical identification includes the name of the place of the origin of the goods, like Banarsi sari, basmati rice, etc. Trade secret. Trade secrets are intellectual property rights on confidential information which may be sold or licensed. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation of trade secret protection. Now, I want to give some brief introduction about the patent, a form of monopoly for a limited period of time intended to encourage disclosure of useful invention. It excludes any other person from manufacturing, using, or selling. A type of social contract between the inventor and the state. An incentive to innovation. The history of patent law in India starts from 1911 when the Indian Patents and Designs Act 1911 was enacted. The present Patent Act 1970 came into force in the year 1972, amending and consolidating the existing law relating to the patents in India. The Patent Act 1970 was again amended by the Patents Amendment Act 2005, wherein product patent was extended to all fields of technology, including food, drug, chemicals, and microorganisms. An invention relating to a product or a process that is new, involving inventive step and capable of industrial application can be patented in India. However, it must not fall into the category of invention that are non-patentable as provided under Section 3 and 4 of the Indian Patent Act 1970. In India, a patent application can be filed either alone or jointly by true and first inventor of his assignee. Patent law is that area of law that deals with an invention exclusive right to use their own invention. It is a right that empowers the patentee, that is called the patent owner, to prevent or stop the use of his or her invention by third party without his or her permission. Patent includes right to license other for the purpose of making, using, or selling the patented invention. Basically, it is a contract between an applicant, that is the inventor, and the government, wherein the government provides right of protection. Government provides right of protection of the invention for a limited period of time after the full disclosure of invention by the applicant or inventor. An invention relating to a product or a process that is new, involving inventive step and capable of industrial application can be patented in India. Intellectual property is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovation of the innovator and the wide public interest, the intellectual property system aims to foster an environment in which creativity and innovation can be flourished. Procedure for grant of a patent in India. After filing the application for the grant of patent, a request for examination is required to be made for examination of the application in the Indian Patent Office within 48 months from the date of priority of the application or from the date of filing of the application. After the first examination, report is issued. The applicant is given an opportunity to meet the objection raised in the report. The applicant has to comply with the requirements within 6 months from the issue of the first examination report, which may be extended for further 3 months on the request of the applicant. After the removal of objections and compliance of the requirements, the patent is granted and notified in the Patent Office Journal. So, the brief process to grant a patent in India can also be understood from the following flow chart. Patent search, filing patent registration application. Next step is preparation of patentability report, review of application, issuance of patent registration certificate. These are the major steps for the filing and getting the grant of the patent. Pre-grant opposition gives third party the opportunity to oppose the grant of a patent just after publication of the patent application. A party need not wait until the grant itself. Post-grant opposition can be filed only after the grant of a patent but within 1 year of the date of grant. So, what are the grounds for opposition can be taken? Some of the grounds for filing pre and post grant opposition are as under: patent wrongfully obtained, prior publication, the invention was publicly known or publicly used in India before the priority date of that claim, the invention is obvious and does not involve any inventive step, that the subject of any claim is not an invention within the meaning of this act or is not patentable under this act. Other grounds are insufficient disclosure of the invention or the method by which it is to be performed, that in the case of patent granted on convention application, the application for patent was not made within 12 months from the date of the first application for protection for the invention made in a convention country or India, that the complete specification does not disclose or wrongly mentions the source and geographical origin of the biological material used for the invention, that the invention was anticipated and having regard to knowledge, oral or otherwise available within any local or indigenous community in India or elsewhere. So, this is all about the today lecture. To deliver this lecture, I have used these references: 4 textbooks, 3 websites and 3 journal papers were used. Thank you very much. Jai Hind.